legal expert, and he joins us now to help us make sense of some of the legal aspects that we heard today. Ulrich, thank you very much for your time this afternoon. Perhaps let's just pick up on what Magudumana's lawyer had to say there in terms of merely asking for this matter to be rolled over, insisting they are not abandoning their client's right to seek bail. What's the difference between having the matter rolled over and abandoning bail?
Hi, good afternoon for having me. Yes, in matters such as this, it is a lot of the times it is in the accused's interest to not bring a bail application and to first see what evidence the state have in their possession that the accused person needs to answer to. The reason for this is because when you bring a bail application, you need to depose to an affidavit under oath. And once you depose to that affidavit under oath, that is your version. You cannot change it at a later stage, and you cannot alter it after having seen the evidence of the state. So that could have been, if she had abandoned bail, that would have been a strategic decision for her to do so. But in this instance, her attorney has indicated that they have found new evidence, and new evidence has come to light, and that they would only like to apply for bail at a later stage on the 16th of May. Whether this is just a strategic move for them because they are not ready to proceed today, or whether they want to first see what happens with the bail application of the other accused, one would have to wait and see. But a person cannot be forced to bring a bail application. She, of course, remains in custody, so it is to her detriment, so to speak, that she only brings a bail application at a later stage. But I think that it is strategically to determine what the other accused are saying before court and what they are placing on record before she presents her application for bail.
Because also the state says they were approached today by her legal team for some information. Is this unusual to approach the state on the day that your client is then supposed to appear before court?
Well, there's no onus on the state and no duty on the state to provide them with any information. If they seek clarity, then they can bring an application for further disclosure pertaining to clarity on the charge sheet, etc. But at this stage, there's no duty on the state to provide them with any information other than the affidavit of the investigating officer when he is opposed to bail, as is the case in this matter, and then a brief outline of the charges that the accused is facing. Only once the matter is ready to go to trial and the docket in the matter has been disclosed to the accused, is the state then at liberty to finalize their charge sheet and to present their case, the contents of the docket, to the defense so that they can prepare for the trial. So it's not clear what further information the defense sought from the state. And once again, it could merely be a strategic move in order for them to first determine what the other accused say in their bail application, and then to adequately prepare for her application for bail on the 16th of May. During a bail application, if there's any indication that an accused person is not being truthful and not being transparent with the court, that would count against them severely, and the court would make a negative inference pertaining to that. So they should be very careful pertaining to what they disclose to court during a bail application. And having said that as well, remember that all accused persons are entitled to apply for bail, and it is the duty of the court to determine whether it would be in the interest of justice to release that person or those persons on bail, and numerous factors are taken into account. Is it their first offence? How severe is the offence with which they are being charged with? Is there any indication that they will interfere with state witnesses? Is there any indication that they will try and evade their trial? So in other words, flee the country and not see their trial through to completion. So these are all factors which the court must weigh up in determining whether the accused person should be released on bail. In her instance, of course, she's going to face an uphill battle pertaining to the fact that she did flee the country with Thabo Bester. She was arrested in Tanzania in an attempt to avoid being arrested, and that will certainly count against her when the court determines whether she is a person who should be released on bail or not.
We also know that the state has withdrawn the charge of murder for these suspects, at least. Will that have a bearing, bar from her, because of the reasons that you have given, that she once skipped the country, so that may impact her prospects? But for the other accused, will that have a bearing at all?
Well, the charge of murder is, of course, a very serious charge, and it should be weighed up by the court when a person applies for bail. But it is the correct thing for the state to withdraw the charges at this stage if they have no evidence to support the charge of murder against these accused. If evidence later comes to light, which indicates that they may have been involved in the murder of the deceased person found in Thabo Beste's cell, then the state could add those charges at a later stage before finalizing their charge sheet. So she's still a big bearing on whether they should be released on bail. It's more going to be pertaining to the fact that they will attend to court until the finalization of their matter, and that they will not interfere with state witnesses pending the finalization of the trial should they be released on bail. And those are going.
Oh my. Ulrich, it appears that our connection is intermittent there. I do wonder if you are able to hear us for this particular question. When it comes to the decision by the court to restrict the media and access to these proceedings, they cite critical issues that may come up. I mean, is this unusual given the public interest in this matter?
No. Certainly not. At the end of the day, it is the presiding officer in the court whether the media should be allowed to film a live broadcast of the proceedings in the court. In this instance, a bail application is, of course, a sensitive application where evidence could be adduced in court which could impact the application of the other accused for bail. And I think that is the reason why the magistrate would have said that no live broadcast is going to be allowed, so as to ensure that justice prevails in court and that the evidence that is adduced in court today is not altered, because of legal teams watching a live broadcast, etc. So I think that would be the reason. It's certainly, since the Oscar Pistorius case, which was the first live broadcast of a court case in South Africa, it's just
Ulrich Roux. Yeah, Ulrich, thank you very much for your time. Unfortunately, our connection will not allow us to continue with the conversation. Ulrich Roux is a legal expert. Thank you.